Good afternoon, Commissioners. This is Troy. We are live and recording.
Good afternoon, everybody, and welcome to our Tuesday, November 7th, 2023 Board of County Commissioners Land Use Meeting and Public Hearing. We'll go ahead and call this meeting to order. If you'll all rise and join me in the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you for that. Attorney Garcia, do we have certification of the agenda today?
You do. The County Attorney's Office has reviewed all items on the agenda, and you have proper jurisdiction and proper notice has been provided on all those items.
Thank you. And do any commissioners have disclosures for items on this agenda?
I have none, thank you.
No, sir.
And I have none either. With that, we'll move to item 2, land use meeting agenda items. We have no items in that category, so we'll press on to item 3, our public hearing agenda items. Item 3A is Fields Preliminary Plan, Project File SB 2022-036. Heather Scott, Principal Planner, presenting for staff. Hi, Heather.
Good afternoon. Heather Scott, representing Planning Services. The item before you today is a continuation of the Fields Preliminary Plan, project number SB 2022-036. The development team has prepared a presentation as well. The applicant is requesting approval of a revised preliminary plan to subdivide a 638-acre parcel into 130 lots and 10 tracts. The 118 clustered lots range from 0.7 to 2.6 acres in size, with an average lot size of 1.04. The 12 large lots range from 10 acres to 56 acres. As part of the preliminary plan, 2 waivers from the Estate Residential Zone District requirements are also requested relative to the large lots. One is of the requirement for central water for all large lots, and the other is for underground electrical distribution lines for the 7 lots located adjacent to Flintwood Road. The intent of the preliminary plan process is provided on this slide. The preliminary plan process begins with the submittal of an application, following a review period by referral agencies and the public. There are public hearings before the Planning Commission and the Board of County Commissioners. Approximately 20 members of the public spoke in opposition to the subdivision design at the Board of County Commissioners' public hearing. The board continued its public hearing to allow the applicant an opportunity to address neighborhood compatibility and input. The board also approved several additional hearing continuances at the applicant's request. The applicant has submitted a revised preliminary plan, which is subject of today's hearing. Public correspondence and referral agency comments related to the new preliminary plan are included in the revised staff report, the supplemental memo that went out on Friday, and additional correspondence was just handed out to the board. Updated referrals were received from South Metro Fire, Douglas County Health Department, Mile High Flood Control District, and the State Water Resource Engineer's Office. Public correspondence received focuses on continued incompatible lot sizes and the potential negative impacts of the project on the rural character and traffic. Engineering Services has reviewed and accepted the revised plan. A Phase 3 drainage report will be required at the time of final plat. As a reminder, the Planning Commission heard an initial proposal for the 255-lot preliminary plan at a public hearing on April 17th, 2023. The Commission unanimously approved a motion to recommend approval of the 2 zoning resolution waiver requests. A motion to recommend denial of the preliminary plan request was made, failing by a vote of 3 in favor and 3 against. As a result, the preliminary plan moved forward to the board with no recommendation from the Planning Commission. The site identified by the red star is located in the northeast portion of the county between Hilltop Road and Flintwood Road, north of Singing Hills Road. As a recap, This site, shown in the red outline, is zoned estate residential. Zooming in on the aerial, the site abuts Tallman Gulch subdivision to the west and Hidden Village subdivision to the south and southwest. There are rural residential neighborhoods to the north and agricultural zone properties to the east. The property was rezoned from agricultural to estate residential in March of 2022. The applicants formally applied for the preliminary plan application in August of 2022. The plan proposed at that time was 255 single-family residential lots. The Planning Commission hearing date was April 17th. On April 25th, the Board of County Commissioners voted to continue the hearing on this item until May 23rd and asked the applicant to further consider neighborhood compatibility and input in the design of the preliminary plan. Subsequent hearing continuations were approved on May 23rd, June 27th, August 8th, and September 12th, with the final continuance being approved for today's hearing, November 7th. This exhibit shows the revised proposed subdivision designed per the ER Zone District standards. The overall density of the project has been reduced by almost half, from 255 lots to 130 lots. A clustered lot layout is still proposed on the western portion of the site. Lot sizes range from 0.7 to 2.6 acres, with the largest of these lots located adjacent to Hilltop Road. On this graphic, 1.5 acre lots are shown in yellow, 1 acre lots in light brown, and 0.7 acre lots are shown in the dark brown. The clustered lots will be served by Parker Water and Sanitation District. Access for the clustered lots is proposed from 2 points along Hilltop Road, one along the northwest and one at the future roundabout of Hilltop Road and Singing Hills Road. A temporary access point will be provided north of the roundabout until construction is completed. 35-plus acre lots continue to be shown adjacent to Flintwood Road and will take access via private driveways. 5 10-plus acre lots have been added to the southwest portion of the project and will take access from a public road proposed to connect to Hilltop Road. These lots will be served by well and septic if the board is to approve the request zoning resolution waivers. A total of 123 acres of this project is proposed for open space and further purposes such as drainage and utilities. For the large lots on the east side of the project, envelopes or no-build zones may be established during the final plat process to protect the drainage ways and drainage channels. The main stream of Tallman Gulch is contained within a Metro District tract running through the center of the property. Drainage easements are proposed over other tributaries that traverse this site. Engineering services and Mile High Flood Control District will continue to review drainage channel design through the final plat process. Zoning resolution waivers shall be approved by the board only upon the finding, based on evidence presented in each specific case, that the approval standards listed on this slide are met. A detailed discussion of these standards is provided within the staff report. Staff has evaluated the waiver requests in accordance with Section 122 of the Douglas County Zoning Resolution. Should the board find the approval standards for the waivers are met, a motion should be made prior to the preliminary plan recommendation. No conditions are proposed by staff for the waiver requests. Section 122 of the zoning resolution sets forth the parameters for the Board of County Commissioners' decision on waiver requests as noted on this slide. The approval standards for a preliminary plan request are set forth in Section 403 of the subdivision resolution and listed on this slide. Staff's assessment of the approved standards are discussed in detail within the staff report. Staff has evaluated the revised preliminary plan in accordance with Section 4 of the Douglas County Subdivision Resolution. Should the Board of County Commissioners find that the approval standards for the preliminary plan are met, the following proposed conditions should be considered for inclusion in this motion. Condition number 1, Prior to board action on the final plat, the applicant shall demonstrate compliance with South Metro Fire Rescue's approval requirements as provided by their most recent letter dated October 26, 2023, and in coordination with the county's chief building official. Condition 2, prior to recordation of the final plat for the 12 large lots, existing well number 126985A shall be capped and abandoned, or a court-approved augmentation plan obtained per the requirements of the Colorado Division of Water Resources. Condition number 3, the applicant shall provide required cash in lieu of parkland dedication fees to Douglas County in accordance with Article 10 of the Douglas County Subdivision Resolution. Condition number 4, payment of cash in lieu of school land dedication fees to the Douglas County School District may be deferred until the issuance of the first residential building permit. Condition number 5, prior to recordation of the final plat, the applicant will record a declaration of restrictive covenants reserving the water rights beneath that portion of the subdivision that will not be within the bounds of the Parker Water and Sanitation District for future landowners. Condition number 6, during construction activities within the development, the applicant, its successors, and assigns shall take all reasonable care to watch for historic resources, paleontological resources, and other cultural history resources, and shall immediately notify Douglas County and complete the appropriate Colorado Office of Archaeology and Historic Preservation data management forms in the event of such discovery. Condition number 7, technical corrections to the record copy of the preliminary plan exhibits shall be made to the satisfaction of Douglas County. And condition number 8, all comments and promises made by the applicant or the applicant's representatives during the public hearing and/or agreed to in writing and included in the public record have been relied upon by the Board of County Commissioners in approving an application. Therefore, such approval is conditioned upon the applicant's full satisfaction of all such commitments and promises. Section 405.08 of the subdivision resolution sets forth the parameters for the board's evaluation of a preliminary plan request, as noted on this slide. This concludes staff's presentation. I am available to answer any questions on the staff report at this time if you wish. Otherwise, the development team has a presentation on their revised preliminary plan.
Hello, thank you for that. So just to clarify, 8 conditions?
There are 8 conditions, yes.
Yeah, thank you. Any questions for staff?
I do have a question for the county attorney. I think I heard staff just say that we need to approve a motion to grant the 2 waivers that are requested before the motion, and so we just have one motion on our log. Could you craft that for us,
I'm
please?
doing that now. Thank you, ma'am.
Thank you.
Any additional questions for staff?
I have none.
Okay. I have a couple, but I'll reserve those following the applicant's presentation if the applicant would like to approach.
Good afternoon, members of the board. My name is David Foster, Land Use Counsel for the owners and applicant here today, address 360 South Garfield, and it's a pleasure to be here with you today. We do have a slide presentation, and before I go any further, I'd also say that so that we don't get stuck with this at the end, we will accept all of the conditions that have been outlined by your staff today.
Great, thank you, Counsel.
Let me begin first by thanking your staff, who of course work very hard, as you know, and then I'd like to introduce our team that's here assembled. I'd like to start with Sharon Walden, Rita Walden, Jan Walden, and Linda Smith. I think you know them as the sisters who have been here on a couple of occasions. Darwin Horan and Tom Clark with Ventana. Rob Fitch and Troy Bales with Rick Engineering. And Rob will be following me in this presentation in just a few minutes. And Rich Fulmer with FHU handling the traffic, and my colleague Amelia Steffen with the firm. We are here on a continued hearing. I know that there has been some concern or representation, probably just lack of familiarity with the process, that it was somehow denied back in April, which I think we all know it wasn't. It was continued. And so we are here, and the purpose of today's hearing is to review our request, preliminary plan, and subdivision resolution. So let me start with this slide, which speaks to the previous approvals. And actually, your staff identified the first one, that in March 2022, you approved the zoning for estate residential. Obviously, it's a quarter, it's a full section, 639 acres. You understand what the gross density was when you approved this as a estate residential. And then what staff didn't necessarily include in their background, but I think it's important for today, is that in May of 2022, you also, as a Board of County Commissioners, approved the Metro District. And in so doing, you'll see that we've included just a small little snippet from your findings that day, that this proposal was in substantial compliance with the Douglas County Comprehensive Master Plan, which is an ordinary finding that you would have made in approving the comprehensive, in approving the Metro District plan that day. And of course, back in March of 2022, you reviewed the comprehensive plan as well. I'm not telling you anything you don't already know. Please understand that. I just want to identify kind of the history and the transparency and the process by which we take an entitlement with what I would argue a lot of discretion at the rezoning, and then we start to narrow it down in terms of what we're actually going to build on the ground. That's done from rezoning to, in this case, a Metro District approval, and now we're sitting here with a preliminary plan and subdivision, which is the next process. That Metro District, and I pulled this out, and this doesn't have to be made part of the record, I just wanted to identify it for you. This was heard in front of the Planning Commission March 7th, Board of County Commissioners April 5th, and I turned to Exhibit E, which is a map of improvements from that approval. And you can't probably see it really great from where you are right now, but what you will see on this map and what was in front of you at the time that you approved it is very much the very project that you saw back in April in terms of the lotting on what we would consider the wheat fields. I know that it was represented that way. So this plan that we're going to review again today, although very modified, has been in front of you on a couple of different occasions and approved, at least from the Metro District perspective, back in May of 2022. It was identified as 255 lots then, and $29 million of debt service was approved through that Metro District. So since the Board of County Commissioners hearing on April 25th, the owners have spent some time making revisions based on what they heard from all of you, and then went back into the community in the middle, late of June to show a revised plan, and got some feedback there, kind of started to contemplate a couple of other revisions. Those didn't work. So we are here with a plan that was submitted and reviewed by neighbors on June 21st, 2023. And it wouldn't be a good land use hearing without a picture of a piece of property from a satellite image. So there you have that. The staff had the same one just a moment ago, showing the section of ground that we're discussing today. So this was the plan back in April of 2023. And as you saw and as you heard, it had 255 residential lots, and 247 of those were identified more on the western portion of the site and they had an average size of 0.3 acres per lot. And there was quite a bit of feedback that we received from the community. Frankly, we got quite a bit of feedback from you as county commissioners as well in terms of what that site looked like and the character of that development. So I'm hitting these buttons a little bit too quickly. So these three areas of concern or of issue from April were around density, lot size, and character. I would say that density and lot size are really objective criteria. We know what the actual numbers are in terms of a density. We know what the actual size of a lot is. Character is kind of more amorphous. It either feels right or it doesn't feel right. I would argue that the density and the lot size add a lot to that subjective feeling of whether or not character is met. And I also had a chance to watch the hearing, so I'm speaking here as though not in a vacuum without having watched the hearing. I've watched it now twice. And so I had a good opportunity to hear what the community was speaking to and also what the three of you spoke to. There were some terms thrown around in that conversation. Things like maybe this was a legal loophole in terms of how this site was being laid out, that there was some fuzzy math in terms of the density and the development, and that, and Mr. Chair, you had said, and frankly I concur with you on this point, that at the preliminary...
That's rare. That doesn't always happen with you and I.
I wanted to at least identify at least this moment.
We'll take it.
You had said that even though we're at a preliminary plan, that you wanted to have more specifics, that while there was no belief in your mind that the applicants weren't going to do what they told you they were going to do standing here at this dais, that you wanted to see more certainty in the preliminary plan level so that you weren't going to be sitting here again at a final plan kind of saying, you know, what gives. And so we have the continuance and we have time to contemplate those things. And as you also spoke rather significantly about, this is a balancing act. This isn't easy. This is development. It's never super easy. And you were hoping to see a better balancing of the lot size and the densities within this project. And Commissioner Teal, you said we had a long way to go in order to get to where you thought this plan should be. So it has taken a long time. I don't think that's exactly what you meant, but we had a long way to go, and I think what you see today is a project that totals 130 lots. Of those 130 lots, 118 of them are identified in that western portion of the site, which is down from 247 previously. So 118 versus 247. And then you'll notice that there is no lot that is under 3/4 of an acre, 0.7 acres, and that the lots that are abutting the Tallman project, which is to the west, are all 1.5 acres in size. And then all of the lots surrounding the balance of the property, which I didn't hear a lot of concern at this hearing back in April, but those are rather significant lots that surround the balance of our property as it relates to the rest of the area. And that's better seen on this chart, I think, in terms of the area character. So as this plan is in front of you today, the per DU the 1 DU per 4.9 acres is less dense than all of the subdivisions to the north, to the west, and to the southwest. Obviously, we have identified on the eastern portion of our site the larger lots that abut Flintwood. And again, that wasn't an area of huge concern for you in this last hearing. I think the areas that we've identified were. And so hopefully you're seeing from this chart as well that the character, density, lot size is starting to make a lot more sense in your minds. And so here's just the side-by-side comparison of the April 2023 plan and the November 2023 plan in terms of the density, in terms of total lots, in terms of lot size. So as staff mentioned, it was almost half of the density was removed, 49% to be accurate, and then 130% increase in the minimum lot size. So we are reducing density and we're increasing lot size contemporaneously in order to help us build the character that we think satisfies the comprehensive plan. And then what we've done here is that, this plan here doesn't really do a good job. I felt like when you look at the plan on the right, those are lots, right? That's not how a house is going to sit on a lot. And so what we did was we really took a deeper dive to better identify how homes were going to sit on these lots. And the ultimate character, the ultimate density, the ultimate lot size is then seen in our November 2023 plan showing the 130 lots. And again, if you're counting lots within the more dense area, that's just going to be 118 within that area. I'm going to invite Rob up to run through his portion, then I'll come back to finish up with a couple of last slides.
Thank you, David. Good afternoon, Commissioners. My name is Rob Fitch with Rick Engineering Company, 8678 Concord Center Drive, Englewood, Colorado. We've been helping support the planning and engineering on the project. And to build a little bit upon what David had highlighted, and to kind of put the 2D plan on the right, which is our current plan of 130 lots, we've generated essentially a rendered fly-through of the subdivision, and this is kind of starting on the easterly side. And so on the right-hand side here, you have an acre to an acre and a half size lots. On the left-hand side, we have the 0.7 to 0.8 acre lots, kind of included in the middle of the development. Kind of coming up towards the northern end of the property, we're going to turn the corner, and you're going to start to see the backdrop of the Tallman Gulch subdivision, and then we start getting into our acre and a half to 2.6 acre size lots. So this is a TIF-scale rendered drawing of the roadway section. We are proposing a rural roadway section in this development, where in the April plan we had a local roadway section. And here are the acre and a half size lots that are buffering the southwest and Tallman subdivision, turning back and looking towards the east. So we wanted to give that perspective view to kind of highlight again the 2D plan, and that fly-through started at the lower right-hand corner, kind of drove through the easterly roadway, took the left, and kind of ended up in the 1.5 to 2 acre lots towards the west. So building upon a little bit of the design elements, we have located 118 lots on the existing wheat fields to minimize any disturbance to natural terrain or undisturbed area on the property. The rural roadway section we mentioned is incorporated. The 118 lots have an acre and a half to 2 acre size lots, 21 of them kind of along the westerly side. And then we have 54 1 to 1.5 acre lots and 43 greater than 0.7 acre lots, kind of right through the core of the wheat field development. And as David and Ms. Scott highlighted, we still have the 12 large lots, 10 plus acres. There's 5 of them in the southwest corner, and then the 7 large lots along the east range in 35 to 56 acres in size. The Wheatfield development is located to existing infrastructure components. All of the lots that are in the Wheatfields are additionally buffered by 129 acres of open space. So there's buffer space to the west of the large lots in between the Tallman Gold subdivision, and then there's open space buffers effectively all around the residential lots. Here's a depiction to show a typical lot of 0.72 acres in the lot layout and size. All of our lots are sized to allow for all principal and accessory uses in the ER zoning. It was one of the items we heard from the April plan that the smaller lots might not be able to accommodate all the accessory structures. This is a to-scale drawing. The principal use is a 3,500 square foot footprint for a building, and the accessory unit is 1,000 square foot footprint that are meeting all the ER zoning setbacks. So you can comfortably fit all of the ER accessory and principal uses on our lots. In the April plan, and still consistent with today, all of the lots on the Wheatfields will be provided water and wastewater services from Parker Water and Sanitation District. The reason they're located on the Wheatfields is we are adjacent to the existing Parker Water and Sand infrastructure. In doing so, we are going to protect the alluvial wells and the groundwater. The 118 lots will be served by renewable municipal water, and then the large lots on the east and to the southwest will continue to be individual well and septic. Another component of the groundwater is there will be a restrictive covenant on the groundwater, so that any of the groundwater that is utilized by Parker Water and Sand has to serve the development. Traffic design elements. We've kind of highlighted the access points for the Wheatfield lots to be off Hilltop and the ultimate roundabout that Singing Hills and Hilltop will have. And then the Flintwood lots, large lots will have driveway access off Flintwood. As we've processed this project, we've coordinated with the county on their Hilltop and Singing Hills roadway expansion project. So our project will have an interim connection to the existing road, and then we have a permanent connection when the infrastructure is built. And in coordinating with the county, as a part of the development, our property owner will make available 42 acres of land that are going to be ultimately required for the future roadway expansion of Singing Hills and Hilltop as a separate project. Utility services, gas and electric will be provided by Excel and Core respectively. All new underground facilities, public utilities will be underground within the subdivision. There will be some existing power lines along Flintwood that will remain in place. Douglas County Sheriff will provide public safety, and Douglas County School District has still provided a well-served letter for the development. And we have had a lot of recent coordination with South Metro Fire and Rescue. As we've coordinated the development with them, we are going to provide 2 new fire hydrants. One's going to be at Hilltop and the access to the 5 lots in the southwest corner. And then we are going to provide a new fire hydrant, which is the furthest extended fire hydrant in the area at the easterly limits of Singing Hills Road right there. In addition to coordinating the project with South Metro Fire, the large lots have a supplemental fire protection plan for them where all the large lots will be sprinklered, any homes on those lots. And then we also have a fire mitigation plan that was required by the county on record for the project. I'll go ahead and turn it back to David to talk a little bit about the waivers.
Before you do that, so for staff, looking for the referral comments in the packet, it says it's on page 22 and 26, and I'm not seeing that. I don't know if it's misnumerated in the packet, but
For all of them or for South Metro Fire? Which one?
for all of them.
For all of them, okay.
And while you're doing that, I know for IT, we migrated to a new platform, and I'm not seeing the bookmark agenda items by category. I don't know if that has changed a bit. I know that helps the Board of County Commissioners navigate these hundreds of pages of documents.
It starts on page 27 of your packet, so the page number in the right-hand corner, not our page numbers, but I think on page 27, for instance, is the state engineer's letter. Are you seeing that?
Yes, what about the standard summary referral comments?
Packet,
Right.
under the matrix.
Right.
I don't think we did a new matrix. We just provided the letters on the new revised plan.
Okay. Where's the old matrix at?
That's in the previous staff report. We could certainly go and make a copy of that.
I would like to see that if you have it while we're waiting. Go ahead, sir.
Thank you. These two waiver requests weren't really objectionable at the Planning Commission, and I know that there was a quick discussion of them back in April. These waiver requests really satisfy the large lots in terms of both water service and burying the power lines along Flintwood. And the staff has done a rather significant job in their staff report of identifying the rationale going point by point. Happy to discuss these. These issues didn't seem to be hugely controversial, and they satisfy the desire to have these larger lots accompany this project. This next slide is something that you've seen because it's in your code. And I think it's just an important reminder of the use of the comprehensive master plan. It is important to talk about character, but man, when you take a whole comprehensive master plan and try and use each of the goals or policy objectives as individual criteria, that's not what the comprehensive plan was intended to do, and I'm not convinced you're trying to do that, but it's just a reminder of how that comprehensive plan is used in your review of this particular request today. And also in your zoning resolution is the lot area related to the ER zone district, and you'll see that flexibility in lot size is allowed in this zone district. We are trying to take advantage of flexibility in lot size, and a lot of that flexibility in lot size allows for us to meet other comprehensive plan goals, namely being on Parker Water and Sanitation. So again, you know these things, they're in your code, but frankly, I think when we have these land use conversations and there are a lot of people here, it's always important so that everybody can have a better sense of how code is read and reviewed and then ultimately implemented. And then we come to the part of the hearing where we talk about the actual criteria that need to be met. And in this particular instance, the subdivision resolution approval standards, 4.0301 speaks to conforming with goals and objectives and policies of the master plan. And we've identified 3. We've had discussions as to more. The staff report outlines a whole host of other objectives and policies that are met. Establishing community separators to maintain community identity and sense of place. I think we've done that better in this particular project today than you probably saw back in April in terms of the larger lots. Ensuring the character and intensity of the development is appropriate for the non-urban area, and encourage connections to central water and sewer district systems when possible. So those are a sampling of some of the criteria within the comprehensive plan. Here we have 40302 addresses the design elements established in Article 4, and what we've done for your review is because it throws out Article 4, Section 404, we added those criteria right under here so that you don't have to flip back and forth. And that first one was an area that there was some time spent back in April. The lots are appropriate size and configuration for the site's characteristics and intended uses, and otherwise capable of meeting minimum zone lot district lot size standards such as lot size setbacks and off-street parking, which it does. And so I think, frankly, the huge reduction in density and the very significant increase in lot size addresses this criteria head on. And I know that it's not your job to care about the value proposition to land sellers and developers, and I mean that in all sincerity. But you can well imagine that coming to you with a revised plan that reduces the density by 50% isn't at a small financial loss, because it is. It's a significant financial investment, or loss, if you will, by doing this. But frankly, I know that both the owners and the developers want to build a community that they can be proud of. And I know it's a legacy project for this family to ensure that when they have left something better, maybe not better, because that's not fair to say, because they have spent their life here, but certainly something that they can be proud of. And this is a project that I know that they're proud of. 40303 conforms with the water supply, and we've spoken to the will serve letter from Parker Water. 40304 provides for wastewater. Again, we have the inclusion agreement in front of you. Hopefully, you'll see that at some point in your packet. And then 40305, 40306, these are a little bit more technical in nature, but those are met as well. 40307, the traffic study has been provided and accepted. Protecting significant cultural land and unique landforms, we've done the survey there. 40309, services have been provided as articulated in the application and staff report. Doesn't interfere with the extraction of known commercial mining deposits, which shows in at least my assessment, and my assessment isn't nearly as important as yours, that this project and this proposal in front of you does comply with your subdivision regulations. It conforms to your comprehensive master plan. It complies with your zoning resolution as it relates to the waivers that we touched on briefly. And it is entirely consistent with the underlying zoning that you as a board approved last year in 2022, and consistent with the Metro District that you also approved shortly thereafter. We're available for any questions that you have. The whole team is here. We are also eager to hear from the community, hoping that many of the changes have been met with a level of support, although from what we've read and probably from what you've read, we're disappointed that we're not here, arm in arm with a project that everybody supports. But nonetheless, it's a great project that we are excited to have you now review and hopefully approve today. Thanks.
Well, thank you for that, Mr. Foster, and thank you to the applicant. I will say kudos to you, sir. I think, one of the issues that you've heard us share with you for some time on a variety of levels involves community engagement and addressing that comprehensive master plan. And from what I see today, and I don't want to predetermine before we hear from the community, but reducing that density by half, as a former commercial real estate attorney, that does certainly resonate as a significant concession by the ownership and the willingness to be a good neighbor. So thank you for engaging in community conversations and doing what you can to make significant modifications. I do have one question for you. So as a former planning commissioner, I know that our planning commission works incredibly hard on that 2040 comprehensive master plan. I heard at one point you indicate that the independent criteria are not determinative, but you're not suggesting that we dismiss the comprehensive master plan?
Not at all.
Okay.
Not at all. I'm sorry if that was...
Not at all. I just wanted to clarify for my board, that is a guiding document.
It is.
And even though it's somewhat subjective, we do take a hard look at that.
And Mr. Commissioner, if
Yeah.
I can also, we're also in a sub-area, and I think it's important, as we think about comprehensive plans, you have the grandiose plans, and then what I think is also even more important is looking at the sub-areas. And here we have the sub-area, and I can direct your attention, to page 3-7 of the northeast sub-area. So as we, as property owners or their council giving direction to folks, I always want to start with the most specific comprehensive planning areas, and then move out from there, because more time has been spent in, looking in a granular, and that doesn't happen in every part of a county or a city, as you know. So when you do have these very specific sub-areas, and in this case, the northeast sub-area, that's where I think even more attention is placed. And I think our consistency with that part of the comprehensive plan is even greater in this particular instance. So, I hear you loud and clear.
Well, thank you for that. Any additional questions for the applicant?
I have none, thank you.
No, comprehensive presentation for me.
Okay, thank you. So with that, I'd like to open it up for citizen comment, and maybe before we do that, I do see one of our principal planners approaching. I assume this is the referral matrix. I would ask, unless there's any opposition from the board, and this is probably directed to our community development, that in our packets going forward, we do have that referral matrix, our approval criteria, outcomes from the Planning Commission just up front. And then hopefully with the IT, we can index by category as we used to. I know we're transitioning to a new system. But with that, let me open it up for any citizen comment. Is there any citizen comment in the room with regard to this item? And if you do have citizen comment, I would ask that if you could just line up behind the podium, you'll have 3 minutes to address comments to the board. And if you want to just state your name and where you're from.
Hello, my name is Carly Toko. I live right on the border of this development plan in Windy Hills. I come today, I was here before, and I come again in opposition. I look at this plan and I see the work that was put in, and I know there was a lot of work put in to make these changes, but I still look at it and I say, if they came with this plan initially and proposed to put 0.7 acre lots on a state residential that has agricultural land surrounding it and large rural residential surrounding it, that still sounds outrageous to me. 0.7 acres, there is nothing close surrounding that. And a state residential is meant to be a transitionary zoning district. How is there any transition? There's no transition there. We go from 1.5 acre lots in Tallman, just that one tiny section of Tallman. Everything else is 5, 10, 30, 35 acre lots. I don't understand a transition from 1.5 to 0.7 then up to 40. I just don't understand the transition there. So if this was presented first, I wouldn't view it as like, wow, what a great improvement. I would view it as like, really, 0.7? So I just wanted to talk real quick about a state residential zoning, and I wanted to talk about some of the other areas that are in a state residential and how they flow from, say, a planned development on a border into large rural residential on another side of it. There are several communities. We have Indian Creek Ranch, 5 acre lots. We have Plum Creek, 2 to 5 acre lots. Chatfield Acre is 1.6 to 2.2 acres, but they have planned development on edges of them. So they have 0.1 acre lots on the edges of them. So that kind of makes sense, a little bit smaller there. Surrey Ridge, 1.3 to 5.2 acres, but they also zoned into 2 separate zones. They did a state residential and rural residential all in Surrey Ridge so that both could comply with the zone. So these waivers, they're just asking to use the land to incorporate it so they can get their gross density, but not comply that land to a state residential. Then why aren't they zoned separately like some other communities have done in Douglas County. I also wanted to talk through the comprehensive master plan. I heard your presentation, and I have to say it did sound like maybe the individual requirements weren't meant to be met, and it feels like they're picking and choosing the ones that they want to comply with. One that they don't comply with is where approximately 50% of the property boundary is adjacent to zone lands or parcel sizes. There are no zone lands that are the same around them. And parcel sizes, it doesn't say gross density, it says parcel sizes. And there's 0%. Thank you for your time. Please consider what we talked through today.
Thank you, Ms. Togo. Yes, ma'am.
I have something that I would like to share with you guys. Can I approach?
Absolutely. If you want to approach our
I don't
counsel,
know
he
who
can mark
all-
it as an exhibit. This is our county counsel just to the left.
Do I need to state my name?
Sure, if you want to just state your name and where you're from.
Sure, I'm Jamie Lemaster, and I am in Windy Hills. So when the developer applied for rezoning back in March of 2021, you guys asked them to please clarify the surveyed acreage of the property and adjust the acreage as necessary in the project narrative. Also within the section, please further describe how the proposed density meets the 50% adjacency requirements. It also goes on to state, the project narrative provides a brief description of the existing zoning and density of adjacent zoned lands. However, more clarification is needed to demonstrate that the proposed ER zoning and density will provide a transition opportunity as infill between the adjacent zoned lands. Please elaborate on this further in the project narrative and add a graphic exhibit that will further support the 50% adjacency requirements, such as a map of the property showing adjacent zonings, lot sizes, and densities surrounding the properties. Then it then goes on with an example explaining that they were supposed to take the total acres and divide by the amounts of lots to get an average lot size. The developer did in fact provide a map as well as a description. If you look at the second page of the packet I shared, you will see their map, and if you turn to the last page of the packet, you will see their written description. The developer is stating that the south adjacent properties of the southern boundaries have a minimum partial lot size of 2.5 acres. Now, if you turn to the first page, the map that has the actual lot sizes, you will see not a single lot size is 2.5 acres. And that had the developer done what was asked and found the average lot size, you will see that it is in fact 6.13 acres and not 2.5 average for the south side. Then when you look at what they was said on the south or on the west side, for some reason they split the west side into a northwest and a southwest. Again, in the document that the developer provided to you guys, it states that the adjacent property on the southwest boundaries have a minimum partial lot size of 2.5 acres. Adjacent properties on the northwest boundaries have a minimum partial lot size of 1.5. Now, looking back at the partial lot sizes for the southwest, only one lot size equaling in 2.6 acres. And Tallman consists of 1.5 acres owned, but have a density bonus which makes them equivalent to 2.5 acres. So if you take the average without the density bonus for Tallman and get the average lot size for the west boundary, it's 2.8. And if you include the density bonus, then you get an average of 3.49. This does not meet 50% of the adjacency requirement for the ER zoning that was granted. In reality, it meets 0% of the adjacency requirements when using the math that was provided in the example. If they had done what was requested by the commissioners and provided the average lot size and number for the zoning requested, this would not have been passed. I am asking that you deny this plan that is presented today, and that you also revoke their zoning it was granted due to falsifying numbers and lying to the commissioners as well as the community. Make them start from scratch, and this time demand that it's done without lies, deception, falsifying calculations, and meets the master plan.
Thank you, ma'am. Yes, sir.
Good afternoon. Hello, my name is Charlie Ricks, I live not too far from the project off Hilltop Road for about 15 years now. I haven't attended the other hearings, but I have looked at the plans the developer has submitted, including the recent revised ones with fewer but larger lots. I think that this new plan is a good compromise for the area, and I urge the commission to approve this plan. Thank you for your time today.
Thank you, Mr. Riggs. Yes, ma'am.
My name is Karen Van Zee, and I live on the north adjacent border of the Waldine property. I would request that I use a proxy for an additional 3 minutes for someone in our neighborhood who was unable to attend, for a total of 6 minutes, if you would give permission.
Ms. Van Zee, do you represent the HOA or do you represent a community association?
But I do have individuals, written proxies, where they're requesting to allocate time to me.
You know,
Commissioner, just so you know, I am the chairman of our community. I'm not.
Sir, you're out of order, so we're just going to take it one at a time here. I think if there is somebody here in our gallery that's willing to take up the remainder of the comments, you're welcome to do so, but it is 3 minutes per person unless you represent a community association.
So to clarify, do I have 6 minutes or 3 minutes?
You have 3 minutes, but I would recommend if you have others here that would be willing to share with you, they're certainly welcome to that 3 minutes as well.
That I am welcome?
Each person gets
each
3
person
minutes
is.
unless
Okay,
you're
so-
the president of a community association, and it sounds like we may have one here.
And I wanted to confirm that the commissioners have a copy of a letter that I directed to be presented to you.
We do.
You have that?
Yes.
Thank you for that confirmation. Now, I don't claim to be a zoning or planning expert, and so in that letter, there may be misunderstandings or misinterpretations, but I do still believe that the general principles of the general interpretation of the area and those statutes, that the comments have validity. We strongly believe that there will be widespread impact that will be very negative for the rural nature of the area, as I stated. I wanted to make one correction. I indicated in the letter that all of the properties that were on the eastern adjacent to the eastern side of the property were 35 acres, but actually I understand that at least one of them is 20 acres, and so I wanted to make that correction. And I wanted to point out Article 1, Section 103, Control over Platting, that the board may suspend or withdraw approval of a plan if it was based on, it is substantially false or inaccurate, or there's new information. My neighbor who just spoke talked about false information which was involved in the underlying zoning approval. So I just wanted to bring that to your attention, even though that does relate to subdivision. That I wanted to point out Section 106, which requires the interpretation. It's the rules, and they say shall. The 106.01 is that they are minimum standards, and then 106.02 is that that which is most restrictive or imposes higher standards governs when there's any conflict, and that there requires compliance with, consistency with, or general conformance with the master plan and applicable rules, private property rights, and property designation as being a primary basis for establishing future use. This is the northeast sub-area, and there's very specific information which I included in the letter concerning that. It must conform with the goals, objectives, and policies of the master plan, Section 403.01. And let me see here. Tallman is not a proper comparison or equivalent. Tallman is less dense than the proposed project. Trying to see if there's anything in particular that I believe that obtaining the zoning and then seeking a clustered development circumvents the intents and purposes of the various rules that are discussed in my letter. And my time is up. Thank you for your time.
Thank you, ma'am. And for the benefit of the listening public, the reason that we have 3-minute time limits is just to ensure fairness to every other citizen, that they also have an opportunity to speak. But thank you very much for sharing with us. We appreciate that.
I understand. Thank you.
Thank you. Yes, ma'am.
Yes, my name is Lisa Fromm. But don't start my timer, because, please don't start my timer yet. Please don't start my timer. I just wanted to talk to you about something very quickly. It is election day, and this is also during working hours, so there are a lot of people that were unable to attend today. So I'm a little disgruntled that you guys are not accepting proxies for time spoken during this meeting.
Ma'am, you can proceed.
Okay. Can I have additional time, please?
You can go ahead. Your time has started.
All right. As I said, my name is Lisa Fromm. I'm a resident of Stagecoach Acres. Our development consists of 10-acre parcels and is located north of the Fields development. I'm also a licensed architect, having 20 years of experience in residential architecture and project development. I'm coming before you today to respectfully ask you to vote no on the current submittal for this Fields development plan. Even though changes have been made to this plan is still in violation of the master plan. And to hear you say, sir, that the master plan is more of a guideline, not a requirement. Every municipality spends massive amounts of time and money in developing a master plan to follow it in order to shape future development. The main reason that you should vote against this plan is that it still is not in alignment with the 2040 master plan and continues to violate almost all of Section 3 under non-urban land use. This plan meets the requirements partially, but the master plan doesn't say you can pick and choose what areas meet the requirements. This is an improvement, yes, from the previous submittal. However, the layout of the previous plan was so out of context for the area, proposing 247 quarter-acre lots. That is absurd that even passed zoning. That is a significant manipulation of land calculations, even in Article 606, saying that lot area can be manipulated. That is a significant manipulation, obviously. Currently, the plan only represents 17% with 21 1.5 acre lots. That is only 17% representative of the surrounding neighborhood. I would like to also talk to you about, you're more than welcome to look up Section 3, but I'd like to talk to you about the community meeting. We had a significant amount of people come to the community meeting and voice their concerns. Our concerns were the density of the area in the middle. It's still, even though, yes, it meets the calculations, visually it does not meet the surrounding neighborhood. This density of 0.7 acres is the same as the Timbers. The Timbers is, under the master plan, considered urban land use. We are in a non-urban land use area. For you to say that the areas are going to be equal in character is not correct. Also, this new plan has absolutely none of the comments of the community were added. Nothing. It was completely ignored. The submittal after that, we asked them to secure the 35-acre lots on the east side so that they would not be further subdivided. The plan after, I need one more minute. The plan after that, they had subdivided all those 35-acre lots into 10-acre parcels after we asked them to secure those sizes so that they represent the other things on the other side of Flintwood. They have not included any of our comments, so for them to say that they have is completely false.
Thank you, ma'am. Welcome.
Good afternoon. My name is Marilyn Kraus. I live in the Hidden Village subdivision, which abuts the proposed division on the south side of Hilltop Road. And my husband and I have lived at the intersection of Trailway and Parker Road Hilltop Road for 23 years. I am concerned about the traffic situation, and not from just complaining that the traffic is going to get worse. I am concerned that this proposal does not meet the requirements of the master plan that says that they will assure that there is adequate traffic control. There's a statement in the application regarding access and road construction. Under Section B, access, the revised traffic impact study states, the study confirms the proposed intersections with Hilltop Road will operate at acceptable levels of service once county improvements are completed. That's the crux of the matter. On May 21st, Ben Pierce came to our Hidden Village Property Owners Association meeting. He is the Hilltop Road project manager and a county employee. He presented the plans for widening Hilltop Road to our association. He handed out the schedule that has been proposed for widening the road from Legend High School to Singing Hills Road. The last segment from Alpine to Singing Hills is the only section that directly abuts the fields. The current timetable anticipates construction to start in 2027 with an estimated 12 to 18-month duration. I spoke with Mr. Pierce after the meeting, and he said, well, practically speaking, it probably will be 2030 before that section is even begun, let alone completed. And yet the entire plan for traffic access revolves around the traffic circle that is going to be built at Singing Hills and Hilltop Road. I propose that until they can prove that the traffic situation is controlled, not just somebody's pipe dream. We've lived there for 23 years. We've had promises for the last 20 years that it was going to be widened. Every time we hear a new promise, it's another 5 years out. So my conclusion is that that's a pretty nebulous hook to hang your hat on that says, yes, we have the traffic situation is all going to be taken care of because miraculously Douglas County is going to have built the roads that we need in order to have proper access to our land. Thank you for your attention.
Thank you, Ms. Krautz. Yes, ma'am. Welcome.
Hi, my name is Kay Marsh. I live in a subdivision called Windy Hills, and what I'm going to address is a little more on a personal side in that when we moved out, the property we bought was from a family called George and Belle Smith, and they were neighbors to the Waldines, and they had just retired. And my concern is not so much the size of the property, although I hate seeing the loss of the quiet and the openness, but for the first time I'm living on a well. And I have here articles from the Denver Post that address in Colorado, residential development and reduced precipitation have increasingly strained the state's groundwater. Again, they address the immediate crisis of the Colorado River has been averted, but now we must turn our attention to the next problem. How will they maintain the drying river at the end of 2026? I'm on well water. If you keep allowing, or everybody keeps allowing people to build, and now we're talking about others going into the well, what is going to happen to my water? How am I going to get water and live on that? And that's what I'm concerned about, is this constant development in open country, and why. One of the fathers of these sisters helped change my flat tire when we moved out there. I mean, it was a wonderful place, and I'm just don't like seeing what's happening. But consider the water. Thank you.
Thank you, Ms. Marsh. Thank you for being with us. Yes, sir.
Good afternoon, Andy Tritley. I'm a proponent of smart growth, the kind of growth that balances the needs and wants and the rights of landowners, as well as people in the immediate vicinity and surrounding communities, local government, public agencies like the school districts, and utility providers. And some locations make sense for higher density and cranes like we see outside the headquarters building here. Other properties for much less density. And this proposed plan for this property is appropriate given that it's just off the edge of Parker with semi-rural areas just to the east. And so with that, I support this plan, and I'm asking the commissioners to support this kind of smart growth with these kinds of compromises and concessions to balance those needs and wants and property rights of Douglas County residents and businesses. Thank you.
Thank you. Yes, sir.
My name is Larry Kruger, and I live in the Windy Hills subdivision, have been there for 16 years, and I'd like to address the visual view of the density and the clustered homes. And can I present some? There's multiple.
Sure, again, if for the record, he's approaching county council, he'll label that as an exhibit for us.
The pictures are view from the middle of Windy Hills from where I live, north, west, east, and south. And you can tell everything's on 5-acre lots or more, with the exception of Tall Man there, as you can see in the distance. So public speaking is one of the least favorite things I like to do, so I'm going to let the pictures speak for themselves and ask that you do not approve the high-density housing going into the fields. Thank you.
Thank you, sir. Mr. Garcia, is this labeled as a particular exhibit for the record?
We only have one copy. Let you take a look at it, and then
Oh, just one copy. Okay.
So are these 3 copies of each picture? So this picture looks like it's the same, and there's 3 of them?
But there are 4 different photos.
Okay.
Thank you.
Thank you, Mr. Garcia, for taking the time to organize that exhibit, and we certainly appreciate that being provided to us. Did you have a label for this?
There'll be labels on that. The marked exhibit has writing on it. This is a copy of the marked exhibit.
Okay, did you want to label this for the record at all? As in?
On that one, I will for the record.
Okay, thank you. Additional citizen comment? Yes, sir.
Thank you for your time, Commissioners. My name is Rob Baker. I live in Windy Hills. I'm a realtor. Don't represent anybody here today other than myself. I'll keep it brief. You guys know what the master plan is. I mean, I do commend the changes that were made as far as where it was to where it is now. As far as the waivers and the changes that need to be made and exceptions that need to be given to approve this plan with the comprehensive master plan, given the goals of 3.2, as well as using those larger parcels to adjust the density. I don't feel that it does fall within the master plan. You guys look at the master plan all the time. You know what it is. And if in your heart of hearts you're like, yep, this is within the master plan, then move forward. But I don't think that I wouldn't believe that would be your thought, that it does fall within, unfortunately, given the statement that, you know, it's subjective as opposed to objective. So, as I'd said, I'm not going to take a lot of time. You guys know what the master plan is. If you feel that it meets that, then then do what you need to do and move forward. But I am, the way that it sets right now, I'm pro-property rights and think people should be able to, do what they should be able to, what legally they should be able to do with their property, but it also has to meet the master plan. So thank you for your time, and appreciate letting me come up.
Absolutely. Thank you, Mr. Baker. Yes, ma'am.
Hello, my name's Kimberly Schrader, and I live in Tallman Gulch. And these 130 or however many clustered homes will literally be in my backyard. My entire street couldn't be here today because they have work, kids, the such. So I will let you know that they all are opposing this as well. So obviously you know that the master plan, those regulations are meant to ensure that developments will blend in and support the surrounding rural community landscape. And the bottom line is, it doesn't. Hiding the 0.7 acre lots in the middle of it, they're still there. You can still see them. The smallest lots right now are 1.5 acres, and that's all we're asking, is that they just at least do that, make it consistent. The other thing that's a concern, if these clustered homes are allowed now, is that going to set a precedent for future developers? All I can ask at this point, you've heard the data, you've seen it, just please do the right thing and make them comply with the master plan. Thank you.
Thank you, Ms. Schrader. Any additional citizen comment in the room? Okay, seeing none, any citizen comment online?
Thank you, Commissioner. I do have a few online comments. I'll first unmute Darren.
Okay.
Darren, you're unmuted. Go ahead, sir. You have 3 minutes.
Thank you. First off, I'm just gonna call this what I see. This just to me seems like a complete joke. We had a presentation that was just given to us that's using, starting point is what I would consider this as pandering. He came in and we're walking back and saying, you guys approved this, you approved the 255 lots, and look at what we now did as a revision to what was absolutely awful, going from absolutely awful to just a little bit better when you have 0.7 lots and clustering, which are two things we all know. It's really basic stuff. But to say that they care about the lots and care about the land, if they could have got the 255 units approved, they would have signed up in 2 seconds. They don't care. That's not, we need to stop putting and injecting philosophy of people's perspective into this and just make this factual. The fact is that you can't bait and switch. You can't show somebody something that was awful just to switch them to something a little bit better and say, look at what we did for you. Look at how great, this is a common sales strategy. This is nothing new. This is just the same stuff. It's clustered. It's 0.7. It's all into one. It's all squeezed into one area. Nobody in the world would go back and look at the master plan, look at the common surroundings if they were doing Sesame Street analysis of like kind versus like kind and say, oh yeah, that makes a lot of sense. All anybody would say is this makes no sense. That's it. It's not complicated. And I don't understand why we keep getting the runaround on this. We're wasting taxpayer money. I pay a lot of taxes to Douglas County, and I appreciate the services that you guys provide for those taxes. But they are wasting taxpayers' money in these meetings, going back and forth, pandering, trying to tell us how to think, how to feel, how to interpret master plans. It's just the same stuff. I don't understand it. If I were in a business and I was doing the sales pitch to somebody, they would kick me out. You're just bringing the same stuff up and just regurgitating it and then acting and celebrating how much you've changed and revised the plan. The bottom line is, clustered homes are not anywhere in this area. They're not even, it's not even remotely close. 0.7 homes are not even remotely close. They know it, and they're trying to stretch you to believe that they've done some miracle thing where they introduced 130 lots versus 255. Come on. This is ridiculous. It's just not complicated. I don't understand this. I don't understand how we keep putting up with the same rhetorical waste of time on this. And I think it needs to be looked at in terms of this is taxpayer money and our taxpayer money, and coming back and spending all this time revising stuff and pandering and telling people how to think, how it should be, how people should interpret certain things, and then sitting there and telling us that they know their interpretation and the interpretation of master plan is just an interpretation. Okay, that's all I gotta say. It's not hard.
Thank you, sir.
Is it possible to get his last name? I'm sorry.
Oh, sure, sir. Did you want to provide your last name?
Yeah, Darren Smith.
Darren Smith.
Thank you, Mr. Smith.
Additional
Okay, we
citizen
do have-
comment online.
Yes, sir. Thank you. We do have, next would be Courtney Martin. Courtney, you're unmuted. Go ahead.
I'm Courtney Martin, Martin. I'm a proud native of Parker, Colorado. I'm calling in to express my support for the approval of this application. This project presents an excellent opportunity for our community and offers appropriately sized lots for the area. As someone who cherishes the idea of raising my family in a place that I've called my home, I'm aware of the diminishing opportunities to do so. This project provides a promising chance for families to reside in a safe and beautiful area. Also, I strongly believe in the rights of property owners. The Waldens, as rightful owners, should have the autonomy to decide the best use of their land. It is crucial to respect their ownership and their vision for their property. I understand there may be opposition from some neighbors, but it's important to consider the broader benefits this project could bring for our community. Thank you for considering my perspective.
Thank you, ma'am. Additional citizen comment online.
Yes, sir. I do have a couple of more. Next is going to be Dave Noble. You are unmuted, sir. Go ahead.
Okay. I hope that you can hear me. I'm calling to voice my support of the Fields project. I believe that the project is well thought out and conceived and will enhance the community. Listening to the various presentations, this project meets all the comprehensive master plan goals and have met the planning department's requirements and guidelines. And as such, it should be moved forward. You, the commissioners, have the statutory mandate to approve the project based on the needs of the whole community. It should not be relegated to a few vocal neighbors. This project has made compromises and accommodations to the surrounding neighbors, and it more than blends into and aligns with the existing neighborhoods in this area. And more importantly, and I believe this, as one who supports and believes in personal property rights, the Waldeens should be allowed to exercise their property rights. As owners of this land, they've watched the development encroach upon their lives and livelihood. They should be extended the same consideration to decide what to do with their land as anyone else. I thank you for the time to express my support for the Fields project and hope you will decide in favor of moving it forward. Thank you.
Thank you, sir. Additional citizen comment.
Yes, sir. Thank you, Commissioner. I believe I have one more. I have a name of UTA. You are unmuted. Please give us your first and last name and where you reside. Thank you.
Sure. I'm Uta Dirka. I reside in the Pinery, and I am participating in this meeting in opposition of the current development plan. I feel the density remains too large. The developer has taken a lot of feedback into account, but I think looking at the map, it becomes pretty clear from the new plans that the areas that are not proposed for development at all are probably too expensive to develop and not in consideration by this developer, and to keep including some of that just to mathematically come out to the residential planning is very disingenuous. Same thing for the 10-acre lots that are only allowed if they receive a waiver. And again, it's really, in my opinion, just there so that they mathematically can tell our commissioners that they meet the density requirements. Looking at the rendering that the developer showed earlier in the meeting, that does not look like estate residential if you compare it to any of the other estate residential neighborhoods. You can, for example, in your packet, look towards the end. There's some commenter that has provided pictures. I'm not sure if that was the same one that delivered some exhibit to you here in the meeting. But it definitely looks different when you look at 0.7 acre lots versus over 2 acre lots, or even 1.5 acre lots like in the Tallman development. And as some residents pointed out, the lots adjacent to the Fields development are all significantly larger. I'm also kind of curious about the whole traffic situation. So the developer mentioned that they will set aside land for the future development of roads, but in the end, it's the taxpayers that have to pay for this. So the taxpayers end up holding the bag for the developer and the landowner derives a benefit because they get all this money. And all the surrounding people that are unhappy with the development are ultimately asked to pay for all the infrastructure improvements that are necessary. It's just the same right now, what's on the ballot, for example, for the schools, building new schools because of all these developments that are way denser than what a rural county like Douglas County should have ever allowed in the first place. So that is my main comment, that I think it's still disingenuous throwing in these lots just to mathematically come out to something and really not meet the spirit of the master plan or the zoning.
Okay, thank you, ma'am.
I have no additional online comment.
Okay. And I'll just ask again, is there anyone here in the room today that has additional citizen comment? Okay. With that, I'll close citizen comment and provide the applicant with an opportunity to respond to some of the questions that were raised in citizen comment.
Thank our community and our neighbors for exercising their constitutional right to be here and to talk about this particular issue, especially on Election Day. I think there are a couple of issues that I want to address. Let me start with that last comment in terms of infrastructure and payment of infrastructure. Again, I'm not expecting her to know this, but the Metro District that you approved $29 million of public infrastructure. That's public infrastructure. That's not private infrastructure for this project. And the value of a Metro District, as many of you know, is so that the general fund isn't necessarily taxed for many of the public improvements for projects like this. But in fact, in a Metro District, there's a mill levy that is placed on each and every one of these home sites. Now, to be clear, we have a lot fewer home sites in this particular plan than you approved last year. But nonetheless, that is the way in which Metro Districts work. And I'm not doing a 101 Metro District tutorial, but I just wanted to be able to address that much of the public infrastructure is paid very much by the very people who are going to live on this property. And that's due to your approval of that Metro District. There have been a few comments about traffic. As I mentioned before, as staff has seen and reviewed and approved, there is no interim traffic concern. That doesn't mean that people aren't frustrated in their cars when they travel places. I've been here my whole life too. I'm plenty frustrated when I go places. But a traffic study is an engineering document that takes into consideration all of the technical aspects, and that has been reviewed and approved by your staff, and there are no interim conditions. And as was mentioned, there's 42 acres that will be conveyed to the county for some of your larger public improvements in the very near future. I think I remember in the last hearing, your staff had acknowledged that those improvements were slated for either 26 or 27, if I'm not mistaken, so that's not too far off. I think there was a slight tone change in some of the comments. I think there thankfully were plenty of people who acknowledged that this was a better project. I'm sorry that some people felt like this was a bait and switch, that these owners and this applicant would have literally gone through that entire process and been in front of you back in April, only to be 6 months, 7 months later down the road with a revised plan. Frankly, I've been representing developers for over 25 years. That's not how bait and switch in the development world works. That was a plan that my clients believed and still do believe met all of the criteria of your code. There was good debate back in April, which caused them to rethink their plans and obviously bring a revised plan. But there is no conceivable way that my clients and the property owners would have spent all of that time and energy and all of that risk by coming in front of you last April, only to think that 7 months later they'd show up with a revised plan that was just better than horrible. So I just want to kind of clarify that. The other piece that I think changed a little bit from a few comments, and again, it's not everybody who presented today, but there were some comments about revoking zoning. Now, I've been coming down to Douglas County for a long time, and I don't remember the last time during a subdivision hearing, I remember somebody making a reference to revoking somebody's underlying zoning. And that is of concern. The zoning, which you approved last year, met all of the criteria. You approved that. And then the Metro District was approved meeting all of the criteria. You approved that. And to now focus attention away from the subdivision, which was the nature of last April's hearing, and focus it on, well, you shouldn't have approved the zoning in the first place, I think is not consistent with what you're here to review today. And so in closing, I would say, and of course, if you have any other questions, we're more than happy to answer. I think this owner, this developer, heard from the community in April, heard from you in April, and made a significant change to their project. That was because of what they heard, not because they didn't think that they had met the criteria in the first place, but they wanted to be responsive. And I think they have been responsive. And there is criteria. There are conditions, there are policy statements in your comprehensive plan that speak to clustering. I'm not going to go through all of the different elements of the comp plan right now, but this plan meets the criteria that's in front of you today. And we are really excited for what would be the next chapter of this project, and encourage you to ask questions, review the criteria, and hopefully today approve the project that's in front of you. Thanks for your time and attention.
Okay, thank you. Anything else from the applicant? All right, well, we have been going strong for a little bit over an hour and a half now. We will take a 5-minute recess for just a bio break. I do want to recognize and acknowledge the effort of the citizens to be here with us today. I think it's a well-stated comment that this isn't convenient. It's the middle of the day, and you all have families and bills and things that you're taking care of. So I have a high level of respect for each of you taking the time to engage in this important conversation, and our appreciation of the applicant as well. So we'll reconvene in about 5 minutes. Thank you.
Commissioners. This is Troy, your host. We are back and recording.
Okay, so welcome back, everyone. Thank you for indulging in a brief break there. I was informed by staff that there is one other citizen that was desperately trying to get in and was not able to. So at the discretion of the board, I'd like to go ahead and allow that individual to be able to comment. Yes, ma'am. And again, if you want to just state your name and where you're from.
Hello, thank you. Guys, in bumper-to-bumper traffic and trying to dial in and be on a video call all at once, so it was a lot. My name is Audra LeBac. I live in the Windy Hills subdivision. I've been listening since this meeting started while I was still at work. I just really want to come back to some important factors. I've been listening the whole time, and one of the big things that bothers me the most is the community outreach, and I would love to just put that in quotation marks. I actually was out of town when they had the outreach meeting. We were out of the country, and we circled back with a lot of our neighbors who were able to be there and talked about it. And they all came away feeling like there was a lot of great suggestions made, and they felt pretty positive that things might actually for once move in a direction that we could create a good partnership with this new development. And then as things move forward, more and more details were coming out that nothing that we said at that meeting was heard. Like, they really didn't make any adjustments. They just kept going with the same plan that you've heard my speeches here before. I've come up in front of you many times. I don't want to reiterate things I've said to you. There is still the signs up from the April meeting around the property. There has been no new signs. So for people who are new to the neighborhood, and we've had some people move in, they're going to have no idea that any of this is going on because there's been nothing new posted. There has been no letters mailed to us, none of it. So I don't really call that great community outreach. That's one thing I really wanted to touch on. The second issue, I'm sorry, I was so rushed to get here. I really want to reiterate back to the beginning. You can spin the tale as much as you want, but the truth is we were lied to in our homes from the get-go. It's why none of us showed up to that very original rezoning meeting. Trust me, we would have all been there in numbers if we had been told the truth, and I don't feel like we'd even be here today if, we were able to speak our mind from the get-go. So I really ask that you take a look at that and maybe kick it back to the beginning and let's start this process over and in the right way. I would really appreciate that if you're not going to do that and we're going to move forward as this is, I really would ask that you hold them accountable to the master plan because what they are proposing is not in accordance with anything that's surrounding. You've heard all the numbers. I've been listening to them, the 5, 10, 20, 30 acres, everybody surrounding them. They are still just, no matter how you spin it, it is not lining up with the master plan. It's not lining up with the area. It is not lining up with the folks that live out there, the families, the community, animals, all of it. I could talk to you till I'm blue in the face. I was so upset coming over here that I couldn't get through. I just really want you to look at the facts, and we want that subdivision. We want it to go through. We just want to be doing this in partnership with them. We all feel very, very passionate about that, but I just don't feel like they're really listening to us, and we want to do something together and do something great and make it awesome for everyone. Thank you for your time. Thank you for letting me speak. I just really it was important to reiterate those facts for me, so thank you.
Thank you, Ms. LeBac, and we appreciate the opportunity to provide for the additional citizen comment. We know how difficult that is. Anything else from County Council in terms of the record on that? We went a little bit out of order.
No, but it would be appropriate for the petitioner to have the ability to address whatever was just said.
I would agree. Would the applicant like to respond? Okay, and they're waiving that for the record. Thank you, Mr. Foster. So with that, I'll bring it back to the board for any further deliberation, discussion, and or motion.
So I'd like to thank all of the citizens who came here to talk, the applicant for their presentation. Reading through all of the packet, I wrote down all my notes, and it was very obvious the changes that had been made from the last period. I think it was April when they came. And here's one document that was in the packet that I thought really was succinct in highlighting the changes, and it's from Rick Engineering Company, dated June 14th. And it says it reduced the total lot count from 250 to 130 lots. And we heard today in testimony that's a 49% reduction in the density, which I think is huge. I don't know that I've ever seen a plan come before us, go back, and then have such a significant change. And so to me, that tells me that the applicant heard the voices of the people in the audience. Reduced the overall density from one lot. It reduced the overall density to one lot per 4.9 acres. That's almost 5 acres. So if you take the entire parcel and divide it up by 5 acres, think about all those straws that would have been going into the aquifer, draining your aquifer. And we heard people talking about the water. One of the preliminary plan approval standards is 403.04, and it says provides for a public wastewater collection and treatment system. I don't know any way that criteria could be met unless the homes are moved more closely together. There is not a financial way for Parker Water or some other water and sanitation district to come in and provide that wastewater system. And what that does is they will be able to use that water over and over to extinction, which is preserving the water that you have for your wells. We heard concerns and comments about property rights. And everybody who owns property has the right to use it. And I believe that these applicants have the ability to develop it according to the standards. I have looked through these approval standards. I believe the approval standards have been met. There was a comment that was made about hiding the houses in the middle. They didn't do it to hide that. I don't think in looking at this, they thought, well, we're going to hide them in the middle so you can't see them. That's the only way that they can do this water plan, so that water can be reused by having those houses close together. Yet there are larger lots all around the outside of it to buffer, to join more, to match what goes on with the neighborhood. I'm interested to hear what my other fellow commissioners have to say at this point, so thank you.
Thank you, Commissioner Thomas. Commissioner Teal?
Well, last time the applicant came before us with this plan, I stated at that time that I was willing to grant the waivers for sections 611 and 612, even though, as the applicant did point out in presentation, I had grave concerns about approving the rest. So if it pleases the board, I'd be more than happy to hear a motion and consider a motion at this time for granting the waivers on sections 611 and 612.
And thank you for that, Commissioner Teal. Just for the purpose of our legal framework, if we were not to approve the waiver motion in 3A, would we be able to approve the preliminary plan in 3B?
I don't believe you may.
Right. So just to clarify for the board, that approval of A is a clear prerequisite legally in order to approve 3B, which I'm sure you were already aware of.
So I'm happy to make a motion to approve the partial waiver of sections 611 and 612 of the Douglas County zoning resolution sought by the applicant in Field's preliminary plan, because the partial waivers do not nullify the intent of the Douglas County zoning resolution, nor are the partial waivers detrimental to the public safety, health, or welfare, or injurious to other property.
Second.
There's a first and second on the floor. Any further discussion? As a former planning commissioner, I do take the work of the Planning Commission very seriously. I take the comprehensive master plan very seriously. And I wouldn't disagree with Mr. Foster that any single provision is not determinative, and I think community development does a good job of clarifying that for the Planning Commission and for the Board of County Commissioners. That said, any waiver of the zoning resolution or a comprehensive master plan always gives me pause. I'll say in general regarding this entire application, rezonings concern me. Deviations from our zoning resolution or our master plan concern me because, again, it just goes back to promissory estoppel. It goes back to, reliance to your detriment upon representations by the county that we will uphold our comprehensive master plan and the zoning resolution. I do recognize the business constraints and the challenges of landowners, and I'm a private property rights advocate as well. I believe these sisters are trying to do their best to monetize their property and reflect the needs of this community, but I really wrestle with the need for a waiver. I mean, if it were in compliance, the waiver would not be necessary. It's rare to see an ask for a partial waiver. So for me, I'm a no on that. I recognize that my board may be in a different position, but I will be a no. Any further discussion? Seeing none, all those in favor signal by saying aye.
Aye.
Any opposed? Aye, and that passes 2-1.
As to the remaining item that's on before the board today. So the applicant correctly quoted me as stating the last time that this came before us that I thought we were a long way off. I thought we were a long way off mostly because I felt like the clustered density that was in the previous plan, it would deny accessory uses that are, I feel like we make a guarantee with our zoning of this is your rights as the resident of a property within that land to do. It's a right granted by your county government. And for us to adopt a plan that I could not see how those rights could be exercised. I could not see how those accessory units could be exercised. That's where I thought we were a long way off. When I consider the plan before us today, however, I do think we've come that distance because I can see from the applicant's presentation that those accessory uses will be allowed. So from that perspective, I do, well, if please the board, I do have a motion to approve the Fields preliminary plan because it does meet all of the approval criteria with 8 conditions that the applicant has agreed to. As presented, project file is SB 2022-036.
Second.
So we have a first and second on the floor. Any further discussion? I would say that the arguments of my colleague are persuasive, and I do recognize the incredible work of the applicant to get to that over 50% reduction. But what resonates with me is one of the citizen comments that just, he kept saying he couldn't understand. And I was thinking, I don't understand it either. I mean, if you had 1 million units on a parcel and reduced it to 500,000, that's over, it's a 50% reduction. Is it reasonable or consistent with our master plan? No, it's not. So in this case, we have clustering. We don't do density bonuses for clustering anymore. Am I right in that, staff? Yeah, so we don't do that anymore, but I know that Commissioner Rapella, who's been active in this, has been an advocate for density bonuses and kind of worked under that rubric when she was a commissioner, so I understand the perspective, but that's not where we're at today. So the clustering and the density bonuses don't really hold a lot of water for me. I think what was persuasive was Commissioner Thomas's comment that the water wastewater infrastructure is made possible by the clustering. And I think it's also relevant that for the purposes of the Metro District, when you have more residences paying into that system through their mill, then a better opportunity for more infrastructure is created. So that is persuasive. But for me, the 0.7 still seems too small and inconsistent with the character of the adjacent neighborhood. And I don't recall the citizen that brought in this exhibit, but this is outstanding. Good job. I know we have something similar to that in the applicant's presentation and in the packet, but Again, we're looking at a north average of 8.6, east average of 18.8, south of 6.13, and west of 2.8. You know, it was said that the average is 4.9, but that's through some creative math. It's an averaging. It's not, all lots are not 4.9, I don't believe. I mean, we have 0.7 lots that just, in my mind, are not consistent with this neighborhood. Other neighborhoods, yes, but in my experience, when you have this many citizens still showing up, something's wrong. Something's off. You know, when you have a lot of community outreach and community support and a plan that makes sense, you don't get a lot of neighbors taking off work to come talk to us. They're by and large on board. So I struggle with this. I'm going to be a no, and again, recognize my colleagues may be in a different spot.
Yeah, I think it's a cautionary tale. And it's really not the purview of this ruling by the board, but it's a cautionary tale to future applicants in terms of how that public outreach occurs and how that happens. I mean, I'm going on 9.5 years of elected office and land use experience in this exact same vein, and I've seen fine plans. Fine plans come before me and my council and our current board that were actually right down the middle of being compliant. And yet, we would see an applicant who did not practice solid public outreach. Now, again, it's not within the purview of this statement. Please consider this discussion among the board all. But the bottom line is, I think, you know, we need to keep our policies of encouraging public outreach up. Perhaps even consider a restatement of those policies as a matter of policy so that staff can be aware of the mind of the board. But I feel like this may be a cautionary tale for those who would come before us in the future on how to proceed with that. I got to tell you, though, ma'am, I really appreciate you bringing forward that map. The only problem is everything that's adjacent to everywhere. I mean, I went back and forth between the maps that we had prepared for analysis by the board and your map. Ma'am, you know, everything that was adjacent, though, was within the plan was bigger. I mean, you know, you point out the density on the southern half, and yet those are where the big lots are. There's an incongruence in the density to the east, directly adjacent to 35-acre lots, which are, you know, could have been zoned A1. So I don't know. I appreciate the efforts put forward by members of the community. Again, if you guys don't show up and you don't put in this work, then we don't have an opportunity to engage in this level of analysis and debate. But I still remain in favor of the motion.
Thank you, Commissioner Teal. Any further discussion?
You know, I'd just like to say that I appreciate the commentary from my fellow commissioners, and I think the bottom line is protecting the water-going future by partnering with Parker Water and having the ability to have reusable water saves your wells from all those additional stresses that could be put on it, which I think is very important, that needs to be considered.
That's a good point. Any further discussion? Seeing none, all those in favor signal by saying aye.
Aye.
Any opposed? Aye, and that passes 2-1. Ma'am, you are out of order. The next land use meeting and public hearing will be held on Tuesday, November 14th, 2023 at 2:30 p.m. We are adjourned.